Hi, I'm Stephen Babitsky of SEAK Incorporated. I'm here today with James Mangraviti, my partner. And we're going to be talking about what happens if you have an absurd opinion and then have to defend that at a deposition or at a trial. Jim has graciously agreed to participate in this demonstration, so why don't we show the demonstration and then go through it and see what we learned from it. Mr. Mangraviti, you're a well-known accident reconstruction expert, correct?
I believe so, yes.
You're not sure about that?
I believe I'm well known, yes.
Okay. And one of the things that you're well known for is having testified in State versus Walker.
I've testified in a number of cases. State v. Walker is one of them.
And in that particular case, the facts of the case are that the husband and wife got into an argument, correct?
Yes.
And then a few minutes later, the wife ran over the husband in the driveway with her SUV, correct?
Yes.
And was your testimony as an accident reconstruction expert that that was an accident? It wasn't attempted homicide?
I ruled that it was accidental, and I can explain why if you'd like.
And you also then went on to testify, after she ran him over one time, she then backed up the driveway and ran him over a second time with her 4,000-pound SUV, correct?
It was 6,000 pounds, but yes.
And she ran him over a second time, correct?
Yes.
Okay. And you testified that not only was the first time that she ran over him an accident, but the fact that she backed up and ran over him a second time, that was also an accident.
Correct.
Okay. And you went on to testify that when she ran over him a third time in the driveway, that that was also an accident.
Yes.
Okay. So your testimony in that case was a woman who got into an argument with her husband, as you said, took her 6,000-pound SUV, ran over him once, backed up the driveway and ran over him twice, went down the driveway a third time and ran over him a third time, that number 1, 2, and 3 were all accidents, correct?
Right, it was the same incident.
And where is Mrs. Walker today, sir?
I don't know.
Well, isn't it a fact that Mrs. Walker is in prison doing 30 to life?
I don't know where, but yes, she is in prison. That's my understanding.
Okay. So your opinion that the fact that she ran over her husband 3 times in a driveway with a 6,000-pound SUV didn't really carry much weight, did it, sir?
Well, she was convicted. I mean, I can't say, what weight was carried, but she was convicted. And
isn't it a fact, sir, that the reason you're a well-known accident reconstruction expert is because you're known for this case, State versus Walker? How many accident reconstruction experts have ever testified in their career that a woman who's in an argument with her husband and then took a 6,000-pound SUV and ran over him once, ran over him twice, and then ran over a third time, that all 3 times were an accident, sir?
I think you'd have to repeat that question, but as I said before, State versus Walker is one of the reasons why I'm known.
Well, let me make it simple. She ran over him 3 times with a 6,000-pound SUV, and you testified that all 3 times was an accident, right?
Correct.
Okay, and that's what you're well known for, correct?
Again, I don't know.
Well, they ask you about this all the time, don't they?
Sometimes they do, sometimes they don't.
Okay, so what we've seen here is a demonstration of an expert who maybe took a tenuous position in a case. Having a person run over somebody 3 times in their driveway and then being an accident reconstruction expert and then saying it was an accident is a tenuous position to take. When an expert like that takes a position like that, they are going to have to defend that position for future cases. As a matter of fact, if you give an absurd opinion, which in my opinion this was, you're going to have to defend that from case to case. And when we actually did this demonstration in front of a mock jury, when we asked about them running over the person 3 times, the reaction of the jury was they just started to laugh. They said, no, a woman that gets into an argument with her husband and then runs him over 3 separate times in the driveway, that is obviously not an accident. So the lesson here is very simple. If you take an absurd position, you're going to have to defend that in your future assignments. And in fact, if it's absurd enough, you may not get any future expert witness assignments.
Steve, what is SEAK and how does SEAK assist expert witnesses?
SEAK is a testifying training company. And what we do is we provide many services for expert witnesses with regard to depositions and other areas of testimony. We have conferences and seminars that we run throughout the year, throughout the country. We also have books on depositions and cross-examination, which people can look at on our website. We have a deposition outline, which people can access for free at no charge at testifyingtraining.com. And also, what we've been talking about before, when expert witnesses find out that retaining counsel will not properly prepare them for their deposition, and when they know they have a challenging deposition coming up, what they can do is they can contact myself or you, Jim, or Nadine at our company, and we can work with them one-on-one to go over their concerns, their issues, and make sure that they excel at their deposition.
Thank you very much.